Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Malter. Michael is a bankruptcy attorney partner in Binder and Malter, LLP, a boutique bankruptcy firm, 25 years. Graduated with a JD degree from the University of Santa Clara School of Law in 1980. He's a certified specialist in bankruptcy law through the State Bar of California Board of Legal Specialization since 1995. He lives in Saratoga with his two daughters, and his outside interests include labradoodles and hiking. And Michael has been an adjunct faculty member at Santa Clara University School of Law since 1985. He is a founder and first president of Congressman Don Edwards' Inn of Court, a chapter of American Inns of Court. So this, it's some sort of little society of lawyers, right?
That's correct.
Okay. Anyway, today Michael and I will be discussing what you should know about bankruptcy relating to individuals. So as we get started, first of all, I'll apologize a little bit. I've got a bit of a cold, so it may sound a little foggy, but I think I'm going to be fine. I think I've got the cough under control here. I apologize to Michael in our little room. But I think we're going to be fine. Now, also, I want to caution, though, our viewers. Michael and I are going to be talking about, again, bankruptcy, which is a complex area. And we are not going to cover everything in our few minutes here together. We're going to hit some highlights. And so this should be part of a continuing conversation that you're going to have with your own attorney and possibly a tax advisor. So Michael, welcome, and thank you for joining me today.
Thank you, Michael.
Okay. Gee, you've been a bankruptcy attorney for 32 years. Is bankruptcy different today from in the past?
It is. Like most things in the world, it's gotten a little more complicated, a little more involved. The bankruptcy law as we know it today really only became law in 1979. So when I started out as a bankruptcy attorney in 1980, the law was pretty spanking new. Mm-hmm. We now have had 33 years under the bankruptcy code and have a pretty good idea now as to how things work.
Well, they've had quite a few changes and revisions even since then, right?
That's correct.
That have happened.
Some for the better and some not.
So what about the types of people that you're seeing now as compared to the past? Has that changed?
Well, it has, especially during this current economic downturn. Unfortunately, the downturn is kind of an equal opportunity destroyer. My clients today very often are doctors and lawyers and the highest integrity, ethical folks. Many people across the board have fallen on hard times since 2007 when the recession hit, and we continue to dig our way out of it.
Wow, okay. Okay. Well, what do you think has been part of the reason why you're seeing this different class of people, aside from just the general economic downturn? Have there been some contributing factors? Or?
There have. I'd say that the greatest common denominator has been real estate, and that many folks who had very good intentions and did their homework invested in real estate only to find their once very fine investments turned totally upside down. And that has just been across the board with my clientele.
Wow.
Real estate remains very hard hit. I saw a couple just yesterday who had invested in 10 investment properties. None of the purchases were with funny mortgages, none 100% mortgages. They had put 20% down, they had investigated the properties. Unfortunately, every single one of the investments are now upside down. And whereas once upon a time these folks would have been set for life, they're now in a very desperate situation.
Wow. Now, were those properties California properties, or
yes.
Yes, all California.
All California. They had, for some reason, identified Fresno as a place to invest. And
Central Valley's been
really hard hit. Yes.
Okay. So what are some warning signs that you should be consulting with a bankruptcy attorney?
Well, I think just generally, if at the end of the month you find that your expenses are outrunning your income, that something's out of whack there without any extravagant expenses. If you take that trip to Paris, yes, you may have a tough month, but if you're finding that the cash flow is very tight despite not engaging in extravagant spending, and to the extent that either, again, with real estate, you're continuing to struggle to make payments on real estate in which the value of the real estate is far less than the debt against the real estate, or for various reasons there's been an accumulation of unsecured debt, such as credit card debt, which the individual can't seem to dig out from under, or if there's been some extraordinary event like a medical catastrophe. If the individual finds that despite all best efforts, there just are not enough dollars to go around, it might be time to consult with an insolvency professional.
Okay, thank you. Okay. Why does it make sense to see a bankruptcy attorney early? Most people are going to try to wait till the last minute. Oh, I'm going to try to, well, so why should they see somebody sooner rather than later?
Well, it's again understandable, Michael, that no one approaches meeting with a bankruptcy attorney with a happy heart, and that's totally understood. But with seeing the attorney sooner than later, there may be some important planning which can be implemented. And it's always far preferable if we can have some time to thoughtfully analyze the situation to make the best recommendation for the client, rather than scrambling hysterically to file a case at the last minute.
Okay. Many of us have heard, these chapter numbers and this other stuff, and for most of it's just jargon. We don't understand it. Maybe you can explain to us a little bit what are these different bankruptcy chapters that apply to individuals, and some of the advantages, disadvantages, and especially what chapter is most commonly used.
Okay. Well, first of all, let's demystify this. The bankruptcy law, the bankruptcy code, is a book. And when you hear of chapter this, chapter that, they're literally just chapters in this book. And the book starts out with the premise that the individual needs some relief. How you spell relief depends upon whether you're looking at Chapter 7, Chapter 11, or Chapter 13 of the Bankruptcy Code. Chapter 7 is the type of bankruptcy most people think of when they think of bankruptcy. Chapter 7 is designed to give the individual a fresh start, to try to wipe as much debt clean from the slate as possible, in order to allow the individual to take a deep breath and get a fresh start, to begin again. It's a very American notion that we believe that people should have the ability, if they fall down, to pick themselves back up. In Chapter 7, there are three things that I look at. Number one, I look to what type of debt the individual is dealing with. Is it mortgage debt, mortgage on a house or on an investment property? Is it credit card debt, which is called unsecured debt? Personal loans, again unsecured debt? Is it tax debt? And in understanding what type of debt we're dealing with, I can initially analyze for my client whether they will get relief through Chapter 7. Not all debts are capable of being wiped out in Chapter 7. For example, most tax debt cannot be wiped out in Chapter 7. And that makes sense when you consider that the federal government wrote the bankruptcy code.
Right.
The federal government may not have a lot of sympathy for Visa and MasterCard, but when it comes to its own income, that's a different story. There are some circumstances where tax debt can be wiped out in Chapter 7, but generally, typically, it is not. So I look to see what type of debt it is. If it is, for example, predominantly credit card debt, medical bills, personal loans, lines of credit. That is the type of debt which can be wiped out in Chapter 7. The second thing I look at is I look to find out what my client's assets are. And we want to know what the value of the asset is, what the debt is against the asset, to determine whether or not the assets can all be protected in Chapter 7. Most people are surprised by the amount of property that can be protected in Chapter 7. And any notion that one has to give up all of their worldly possessions to file Chapter 7 is mistaken. That's a misconception. Mm-hmm. So we look to evaluate the assets. The last thing that I look to is the basic question of, is the individual qualified to file Chapter 7? And that can sometimes be a sticky question. That was a question that didn't exist when I was a baby bankruptcy attorney in 1980. It's a function of changes to the bankruptcy code which occurred in 2005. Mm-hmm. In 2005, Congress set about to modify the bankruptcy laws and, in my opinion, made a bit of a mess of it. But these changes involved determining who can and who can't file Chapter 7. And that's involves some testing called means testing. Mm-hmm. So if a majority of debt can be wiped out, if the assets can be protected, and if the individual qualifies, they may be a candidate for Chapter 7. The second type of bankruptcy is called Chapter 13. Chapter 13 is a form of a payment plan. It's typically a 5-year payment plan, and we take the individual's debts and essentially put them in one pile. It's a form of consolidation, and determine what amount of monthly payment will be made on that debt over a 5-year period. I look to Chapter 13 as a fallback to Chapter 7 if either the debt is a type of debt that can't be wiped out in Chapter 7, like tax debt, for example, or the individual has more asset than I can protect in Chapter 7, or the individual doesn't qualify for Chapter 7. So these are all instances in which I may look to Chapter 13 as a fallback. The third chapter of the Bankruptcy Code is Chapter 11. Chapter 11 is most typically thought of as corporate reorganization. It's what Lehman Brothers is in, what PG&E was in, what Macy's has been in and out of. And although it's usually thought of as a corporate tool, it is available to individuals. And we will look to Chapter 13 if Chapter 7 doesn't make sense and the individual doesn't qualify for Chapter 13. If the individual's unsecured debt, like credit card debt, is greater than $360,000, they don't qualify for Chapter 13. If their secured debt, like mortgage debt, is greater than approximately $1.1 million, they don't qualify for Chapter 13. And in those instances, we may look to Chapter 11 for relief. Unfortunately, because Chapter 11 is a very complicated proceeding, it's also very expensive. And if I'm with an individual who could either qualify for Chapter 13 or Chapter 11, I'm always going to want to try to make Chapter 13 work because it's far less expensive.
Okay. Okay, so you've talked about it. How about now business debt? How does that play into this eligibility for bankruptcy? And especially, why is this important for real estate investors?
Well, business debt plays an important role in going back to that third prong of Chapter 7 of the question of, does the individual qualify for bankruptcy? If the majority of an individual's debt is business-related debt, they automatically qualify for Chapter 7 bankruptcy. And all of the rigmarole of the testing does not apply. So that, for example, the individuals I spoke of earlier who had the multiple investment properties in Fresno, when you added up all of those all of the debt on the investment properties, that's considered business debt. And for these folks, that amount of debt far outweighed the amount of debt they owe against their personal residence, which would be considered consumer debt. So I guess the only silver lining to the disastrous Fresno investments is that those people clearly do qualify for relief under Chapter 7.
Okay. Why should you see a bankruptcy attorney before going ahead with a short sale? Maybe this has changed a little bit in the last couple of years, but maybe you can comment a little bit about that.
Yes, it has changed. I think to some degree. The banks have taken a different attitude in regard to short sale than when you and I first spoke a couple of years ago, in that the banks have finally come to realize that they make out better in a short sale than they do through foreclosure, and I guess that's good news. However, for individuals, there are many considerations going into looking at the option of short sale. One of them is looking to the tax implication. The short sale can involve forgiveness of debt, which can generate a tax, as you know, Michael. And there is a good question that the individual should look at with an experienced professional as to whether the relief from the debt that they would get from short sale is worth it once they look at the tax implication. Bankruptcy is one of the few times that the tax generated by forgiveness of debt is wiped out, and that can be a benefit of a bankruptcy filing. It still is true, even though the lenders are more amenable to short sale than they used to be, that they're a tough haul, and there is a good consideration for the consumer as to whether it's really worth it for them to go through that sometimes torture of a short sale rather than just filing bankruptcy.
Right. But there hasn't been some legislation so that consumers now get, I may say debtors, get more relief and liability protection than they once did for the cancellation of debt in a short sale. And it's actually in some ways superior than, for example, a foreclosure.
That's correct.
But again, I want to make clear something that Michael was saying, and that is, when you have a cancellation of debt in bankruptcy, that is not taxable. And it's the best one, the best exclusion that we have, and so it's a super advantage of bankruptcy as opposed to other types of eliminations. You don't have to prove, for example, as you do with an insolvency situation. I mean, you have to do accounting work. You have to pull together records. Well, the bankruptcy process basically takes care of that for you, and so when you have a cancellation of bankruptcy, then it's just not taxable, and it's a real definite advantage of that.
Well, if I may, I think there's a lot of balancing to be done, and why, again, involvement of a qualified professional is important.
Yes.
There is a slight benefit to one's credit in doing a short sale versus foreclosure.
Yes.
But you have to weigh and balance that against many factors, and one of them is just the stress of a short sale.
Right, right. Because they can be very time consuming. And it ain't easy.
It ain't easy, is right.
Okay. Let's talk, we're sort of around in the real estate area anyway. How are obligations for real estate different from other debt in the type of work that you do?
Well, real estate obligations are typically not discharged in bankruptcy. So if you have a mortgage against a residence or against an investment property, that mortgage is not wiped out in bankruptcy, and that makes sense. If mortgages were wiped out, every homeowner in California would file bankruptcy by this afternoon. Those debts remain. However, if the individual decides that they're going to walk away from the real estate, so let's say, for example, there's a first and second deed of trust on the property. If the value of the property is less than the total debt, very often in a foreclosure, the property owner will still be left owing that junior deed of trust. Bankruptcy is a tool by which the individual walks away from the real estate, and then the obligation on the junior mortgage is wiped out in the bankruptcy.
Okay.
Again, to enable a fresh start.
Okay. And so I understand this is called loan stripping or something like that?
Well, that's a different issue.
Maybe you can explain that a little bit.
Yeah, lien stripping involves a situation where you have a residence or actually any other piece of real estate in which there is no equity to cover the junior mortgage.
Mm-hmm.
So that, for example, the value of the house is $500,000. There's a first deed of trust of $500,000 and then a junior deed of trust of $200,000, let's say.
Mm-hmm.
In that situation, all of the equity is covered by that first deed of trust. There is not $1 of equity to cover the second deed of trust. In a Chapter 13 filing, and only in Chapter 13, the individual has the ability to strip off that second mortgage from the real estate. And that's what lien stripping refers to.
Okay.
But it's very important to understand that there can't be $1 of equity to cover that second. So in that hypothetical, if the value of the property is $501,000 and the first is $500 and the second is $200, you would not be able to strip off the second because there's $1,000 of equity to cover that second.
Okay.
So these lien strippings are only found in Chapter 13. They very often involve fact-finding by the court as to what the value of the real estate is to confirm whether that second is totally underwater as opposed to only partially underwater.
Okay. So it's an important one to know, but it's got a limited applicability because you may have some equity that's available related to that mortgage.
It nonetheless is a facet of Chapter 13 that many individuals have availed themselves of. It's the only silver lining to seeing one's residence being horribly upside down.
Yeah. Do you have a choice about whether you keep your real estate when you file for bankruptcy?
Yes, you do. Typically you do. And in regard to residences, for example, there's no question that even if the residence is upside down, if the individual filing wants to retain their residence, they can do so. They have to continue making the payments. They're not freed from that obligation to make the payments on the mortgages. But assuming that that's their choice, they will be permitted to do so.
Okay. So, again, you and I last met, talked about some of these things a few years ago. What's happened with the loan modifications? Has that become a better process? What are you seeing that's happening with people related to this?
Well, they remain a really arduous process. I'm always telling my clients that engaging in loan modification is absolutely an exercise in perseverance. It's still true that they are very time-consuming. They're painful processes. But what has changed since our first conversation is I am seeing more of my clients being approved for loan modifications. When loan mods began in around 2008, I wondered if they were ever possible. It was so rare to see a client succeed. I'm now seeing more clients succeed with loan modifications, so I don't think it's a total myth.
Mm-hmm.
But some of the things that were true before still are true, that I hear reports constantly of the lenders losing the paperwork or saying that it hadn't been received, and the poor individual having to, again, put together all the financials. So for my clients who are attempting loan modifications, I urge them to keep very careful record of exactly what they send the lender. Make sure to make a copy for themselves. Don't be surprised if they have to resubmit all over again. But as I said, perseverance is the key, and eventually you might just get through.
Okay. So, and again, keep those copies. People are awfully, I found, careless about their record keeping, and it becomes awfully important related to people, particularly when they get into these insolvency situations and they have to document everything for your filings and for these loan modifications and so on.
That's absolutely true. And for anything that you send to the lender, make a copy for yourself. Have a duplicate of exactly what you've sent to the lender. And in God's name, don't send originals.
Okay, good. We have a couple minutes left. Maybe you'd like to offer some final words of wisdom for people that are in maybe a financial jam and thinking about, should I be seeing a bankruptcy attorney?
Well, I think it's always a very difficult decision to go see a bankruptcy attorney. It's a very, very stressful situation for anyone to find themselves in. What I would urge consumers is to go and see a qualified professional. You know, unfortunately, with the downturn in the economy and some other areas of law being a little slow, you've had folks spring up who suddenly are bankruptcy experts. As is always true, when you're going to see any professional, make sure you're going to see the right professional. And preferably try to find somebody through a referral. If you know an attorney in another area of law, see if they can refer you to a bankruptcy attorney. But it's absolutely fair to ask the attorney you're going to see how long they've been doing bankruptcy law, whether they're a certified specialist, and just be sure that you're seeing someone who's qualified.
Okay. Michael, thanks so much for joining me, sharing this important information. Folks, insolvency, financial difficulty, it's no fun. There's a lot of emotional pain that's involved. But it's good to know that there are people like Michael that are available to counsel you. And that's what they're there for. They're there to help. So we'll see you next time on Financial Insider Weekly.